Greetings and salutations. Welcome back to another episode of the Legal Beagles. Today we're talking with Brandon Spencer from Georgia, who his name in Telegram is Perry1871, and he has started two cases. One, he got pulled over for a traffic citation, and the other is about records from the school board that were what they were teaching his kids, and he was trying to get a look at that, and they're trying to stonewall him on all of this. He's gone through 2 years of this now, I believe, and back to square one on one, and the other one is progressing, but we're going to get into all those updates today. All his documents have been posted in the Telegram groups, so if you want to take a look at any of those, by all means jump in, and should be easy to find. So without further ado, here's Brandon. Welcome, Brandon. Thank you for being here. And for those of you who don't know, his name is Perry in Telegram.
Thanks, Gary. Yeah, appreciate you having me, man.
Of course.
So I was telling you earlier, I feel guilty not watching as many videos as you guys have created as I would like, but appreciate all the work you guys are doing.
Well, they're there whenever you need them or want to look at them. Not a problem. Good. But yeah, people do seem to enjoy hearing the backstory of everybody that they've been following and reading their writings and of that nature. And it's been I think a gratifying endeavor so far.
Yeah, I connecting with people, on a more human scale as opposed to just chatting is always good. I suppose my story is probably similar to most. Typical. Uneducated American, lazy, just doing the family thing, the work thing, and then COVID rolls around and kind of just like, wow, this is pretty amazing that government has their tentacles and pretty much everything we do. It was just for us, and we were in Georgia. Our particular city, at one point turned into a ghost town. Crazy, nobody on the streets, nobody working. I'm a contractor, and so we rely heavily on permits, to do various projects. And so our city shut down for a good 6 months. Some municipalities shut down for 8 months, and so it turned into real life real quick there for a minute. And I think the biggest issue was just not understanding what was going on. How could they do this? What options do we have? I think, a lot of men are fixers and want to go and fix stuff, and not knowing how to fix something is just, creates a hopeless feeling. That's not fun. So that kind of drove me to law. And, it was crazy. I had always known that there was, 51 constitutions and not just one. And I just didn't really understand the implications of all of that, but, once I, could kind of peel that back and apply that, and practice, it kind of opened my eyes a little bit. And then, of course, your typical avenues, jurisdictionary is a great, great tool. And that really is just when things became real. You could take, all your theories and everything in your head and kind of put it into practice. And so I guess I'm similar to, what I would think would be many that kind of stumbled upon it, in that regard. And, just kind of, once I figured it out, I looked for, opportunities to apply that stuff in real time. And, it was interesting when I kind of felt like I was ready to actually go into court. I ended up getting pulled over, which was a bit, ironic. And I was charged with driving with unregistered, tag, and pretty cliche that folks tend to talk about. So, I have a couple of cases. I think the tag case is pretty good, only because of, as it relates to Georgia, our motor vehicle, act, Title 40 is, it's just crazy how much of due process has been removed via, the codifying of that. And so, high level, started in municipal court, transferred to state court, appealed, or actually filed a writ in Superior Court, then appealed that, and that was denied, and now I'm kicked back down to state court and have to essentially start all back over again with the initial motion to dismiss. So it's been a long road. I mean, that's I don't know, we're almost 2 years now on that one. But they're before they get my $100 fine, they're gonna earn it. That's what I gotta say.
For sure.
But
So what was it that broke the were you studying law before you came across an issue you needed to act on, or was there something that triggered it and you said, okay, we got to go find out?
yeah, there was. I don't think that I was studying law. There wasn't something that I, frantically tried to prepare myself, a defense on. I had been taken to the cleaners on some stuff in the past, just from a business standpoint, and your typical stuff, I guess. Didn't know much and hired an attorney, and didn't now now I know what I know. I realize that he didn't know much, and I got taken to the cleaners financially on that. But I think that was pre-COVID. That happened kind of leading up to COVID, and then all the COVID stuff started to happen. And so it's just kind of one thing after another. Like, there is no way this is the America that I've heard so much about, that our parents talk about, that our grandparents talk about. Like, there's just no way. And I mean, lo and behold, when you start peeling the onion back, you can really see how I've said it to you many times, how the doing business as usual has become the jurisprudence in America. And not that it's right, just it's just how things are. It's what we're used to. And like I said, before getting on here, I mean, it's our own fault. We once you understand your role as one of the people, you realize that, wow, to do something about it, or they get so uncomfortable that they run away from the fight. And I wanted to do something about it, and kind of make up um, for the vacation that we took. So anyway, yeah, no, nothing drove it to it. Again, it just kind of aligned, kind of perfectly, where I felt like I had studied enough, understood enough, and then I get pulled over, and that was kind of the start of stuff. And then one thing after another, stuff just started happening, and I started filing cases. So that's how it started for me.
And so did in the municipal court, give us a little background of what happened there.
It's funny. My, typical pulled over, got a UTC, uniform traffic citation, show up, to my first, appearance. And, it was just such a circus in there. It was like, um, I guess it was like, similar to being on like the stock floor. Like, okay, you want 500, you 1,000, you 250, you all right? How much do your ticket want to be? And it's like just this haggling. It just, it was so terrible watching this establishment, this entity take control of people like that, or extort people like that, rather. But I mean, I went in there with it was leading up to it. I had my ticket, and I was, again, I had known that I needed to get all my stuff in, try to file all my motions, and the clerk. I mean, municipal courts, more or less, at least in Georgia, they're kind of like little podunk cities, that just, I mean, the judge was a defense attorney, in another county, and it's just such a rickety, type of operation. But the clerk, is some lady who, just, I think she does other municipal business, handling building permits, taking in, motions, or, doing court. It's just really, really strange, the lack of training and expertise that was exhibited. But long story short, reached out to her, tried to file some motion to dismiss, um, and she wouldn't allow me to file them. So she said I had to essentially bring those in, and save them for your oral argument, which more or less was an arraignment. Unbeknownst to me, I was showing up to plea, which I wasn't there to plea. You guys need to convince me, or you need to convince the record, rather, that you have, obtained jurisdiction over me. And that would, I went in there thinking that the police officer was going to be in there, and we could have, I had a little exam. I could bring my evidence. We could, go through it all. And that wasn't the case. But I went in there with my motion to dismiss, and I was smart, I suppose, and asked. I petitioned the court to use a recording device, and he didn't know me, but he granted that. And so I went into the whole motion to dismiss, and we'll get into that, where a lot of stuff will come to light in the appellate brief. That was obviously filed later. But so he didn't think anything of it, right? I'm sitting there recording all this stuff, and I'm recording all of his violations, as it relates to procedural violations, which got enumerated as errors later. And he denied it, of course. I mean, I'm not sure if I've ever heard anybody get a fair shake in municipal court, and to be expected. But when he denied it, he immediately set the proceedings for trial. And he didn't ask me for my plea. He didn't ask me for a jury trial, or rather a waiver of my jury trial rights, and all of those things. The record has to perfect all of those things. And so, how are you able to schedule a trial, a bench trial, that is, in the municipal court, without even getting a waiver of my jury trial rights? And so when I went back in there, before I went back in there, I filed a writ of prohibition in the Superior Court of the county, and trying to restrain them for proceeding with its adjudication process. And that was big fun when I go back in there. Had filed that, hadn't got a decision yet on that particular motion, and so when I went in, the judge just kept his mouth shut. They called in another prosecutor in there, different than the original guy, and I guess one that has some experience with actually litigating. And they immediately wanted to. First of all, they didn't allow me to record anymore. They knew exactly where they messed up on the first time, and so they immediately wanted to transfer it out of state court, so it could deem the writ of prohibition moot. If there wasn't an action in front of the municipal court, then that will kind of give the judge in the Superior Court something to hang your hat on. So anyway, all that went down. Again, no waiver of jury trial, no plea, no any of the above. And then it got transferred to state court. Well, in the meantime, before I had my state court appearance, the writ of prohibition was denied. They filed for a motion to dismiss, and I responded to all that, and then all that was denied. Well, then I appealed. That's the order that I appealed, not necessarily. Well, it wasn't the driving with unregistered tag. It was the actual writ of prohibition. So that when I appealed that essentially stopped the state court process. I went into what was supposed to be my arraignment, and showed them. I went in with my motion to dismiss to start the whole thing back over again. And of course, when I brought up the fact that jurisdiction can exist in two places, and the appellate court has it, he had to do nothing but grant a continuance, and he's been granting continuances for, I don't know, I'm on my fifth continuance, because the appellate court just drags their feet. I mean, it was a 7-month process to get an opinion back from the appellate court. So that was, kind of frustrating. But anyway, since then, got that back, and they denied it. And it's funny, and we'll go through this. The Superior Court basis for its denial, and the appellate court's basis for its denial was saying that they want me to go through the adjudication process, and if found guilty, then you'll challenge all your jurisdictional issues at that point via an appellate or an appeal. And it just, the purpose of a writ of prohibition is to restrain a lower court that has failed to vest itself with jurisdiction. And here it is telling me, well, no, you got to just close your eyes to that, and get convicted, and then you can challenge all that stuff. And really the specific terminology of a writ of prohibition is if there is not additional remedy available to you at that particular point. And my argument, outside of being denied a trial, which I'm arguing is mandatory for a writ of prohibition, and we'll see that in the statute here, but also the order that denied my motion to dismiss in the municipal court wasn't a written order; it was an oral order. And so I had literally nothing to use to file an appeal on that order. So even, because that was one of the arguments, or that was in the order of the Superior Court judge denying my writ, was that I could have appealed that motion to dismiss. Well, no, I couldn't have, because the appellate court won't hear matter that doesn't have a written order, and it's not technically considered an order if it's not written and filed into the record. So they overlooked all that, of course, and said, no, you still had, legal remedy. And the legal remedy was, go get a conviction and, then appeal it. It's just, in my opinion, an oxymoron. It just doesn't make too much sense. But,
Well, do you think that they know they were aiming for the Heck doctrine there, or you think that they just didn't know procedure, or they were trying to railroad you? What do you think?
yeah, I don't know. So Wallace was the judge on my writ of prohibition, and she had just got put on the bench a year prior. And I'm not sure if she's going to take anything. I mean, I think a lot of what we're doing, we could all agree, are not pushing the boundaries of law, but we're asking them to adhere to the black letter aspect of it. And I think, again, this doing business as usual mindset it's just infected the legal system. And so I think that when folks are looking at some of these novel arguments, they're just not even considering what the law is saying about them. I mean, and look, to play devil's advocate, they've provided citations and they've come up with their conclusion of law. I'll say that you know technically speaking, allows them to hang their hat on something. But see, they could hang their hat the other way too if they wanted to. It's just they just don't want to touch it. They just in the world of being a hot potato, they don't want to they don't want to be the one, right? And I mean I understand that. What I don't understand, so as it relates to the denial of the writ, no, I don't think I don't want to give them too much credit either. I don't think that they're trying to go after the Heck doctrine or any of the above. I was more shocked at the appellate level, whereas again, the 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 available remedy of going through the adjudication process and potentially being convicted and then appealing is your remedy towards challenging the jurisdiction. That to me is it's just I don't understand it. I just don't I mean, the whole point of the adjudication process is to make sure due process is followed at every step of the way. And if you haven't, like in my arguments here, I mean you got to go back to the when you got pulled over on the side of the road by the police officer. Did he do that properly? Did he have a basis to pull you over? And if he didn't, then there's no way that this action even commenced. There are no primary pleadings that are in this court's record. There's nothing for you to even consider. So before we get over these threshold issues, we don't even need to be talking about the merits of the case. We need to verify that you guys commenced the case accurately to begin with. And I think so many times, like one of my arguments, when you're make no mistake, when you get a UTC, uniform traffic citation on the side of the street, you are being arrested. If you look carefully, especially in Georgia, you're giving your license as a form of bail, to that particular officer. I mean, for lack of a better term, there is a proceeding that is going on the side of that street right there, and in some of the statutes, they're gray. And again, this doing business as usual overlooks the fact that when you give bail, quote unquote, whatever that is, money, license, whatever that is, or a bondsman, whatever, they look at it as you're waiving your right to a commitment hearing, which is a pretrial hearing. And this is, in a warrantless arrest situation, this is your opportunity for a probable cause determination, a judicial probable cause determination. And in Georgia, we have an adversarial probable cause determination hearing where I can be there and I can present evidence, I can cross-examine, blah, 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 and then probable cause is determined, and then the case is committed. And usually at that point, the way the law reads, they should have transferred that UTC into an accusation or an indictment, and so anyway, my point in saying all of this before, getting into the granule of it is that, you know, oh yeah, giving your license as bail is just, how we do things. No, when you do so, although the black letter doesn't specifically tell you that you're waiving your right to a commitment hearing, that's just how we treat it. And we're going to skip all that stuff and just send you straight to your arraignment where you plea, whatever it is that you plea. And I mean, in my understanding of what I'm reading here, that is exactly what a writ of prohibition is for, to stop y'all fools from doing that, and where does, what's amazing to me is that there's nothing that, is required of them to put in the record that verifies that this process was done. It's just, you give your license, you waive your right to this, that, and the other, and it's just understood that way. Like that's bull. That's amazing to me that's just not how the law reads when you read it. And so anyhow, that's just kind of I guess a longer way of summarizing this particular case. But you know, uh, I think that the key here is you got to, many people on online, will help you train your brain. You have to look at it from commencement. You got to look at it from, I'm an American, I'm free, I'm just doing my thing, and then something happened. Well, from that point, that's where your analysis needs to take place in terms of, due process and those rights being maintained throughout the entire adjudication process. Just that brief interaction with the police officer, is he trained and does he have authority to pull you over in that particular offense? I mean, most police officers are only trained to do a handful of things, and not all of them are trained to administer traffic offenses. So you just, I don't know, I guess if I were to be asked to, give a suggestion or a piece of advice, it'd be, look at it from the date of commencement, the day that, somebody interjected to you being an American, and look at it from there, and then just flip the law on their face and make them answer for it. And look, hey, what do we want to do? We want to, waste 2 years of the court's time, my time, everybody's time, go through the entire process, convict me, and then I appeal it again over $100 violation of my tag registration, then so be it, man. I mean, y'all aren't getting my $100 bill until somebody here owns this thing. Y'all can keep kicking the can down the street on technicalities all you want and say, oh, you'll later be able to test the jurisdiction of the whole process. Fine. And look, I'm not trying to ask y'all, I'm not trying to get out of adhering to the law, the same law that I want you to adhere to. I'm not trying to do that. I'm just asking you to adhere to it. That's it. You do your thing, I'll do my thing. We all just adhere to the law. And we have this happy little Republican form of government. And that would be great, but until we do that, until we can both check that box, let's not count on me giving up, because that's just not going to happen here.
Yeah, that don't you come in here with your black letter law reading and not adhering to policy. We're not going to have any of that, because it's going to affect our revenue stream, and we can't we can't have it. And so yesterday, just real quick, we released David Merlin did an interview with us, and he highly recommends writing private criminal complaints and put with your motion to dismiss, against the people that are involved. And he said that tends to straighten them up a lot faster when you do it that way. But file it into the court with your motion. You can file it with the DA in the next county and stuff if it happens to be the judge or whatnot. And so I would, are you looking into maybe holding some of these people account, like the judge? Has he done some illegal things? Obviously, if he's ignoring jurisdiction, which is a threshold issue, then is he not violating due process?
Yeah, I mean, and some would argue that that's a high crime. Quite honestly, I mean, you were elected into a position to do a job, and you're doing something outside of that job, and the worst part about it is you're in the business of dealing with people's lives, and that's that's yeah, I believe that, that should be held to the strictest scrutiny. And yeah, I have not filed criminal complaints. I know a lot of people have done so, and you hear the back and forth or what have you. But I think that it's a great way to set yourself up for the post action after all of this, and is adjudicated in your favor. And so I think on top of looking to developing your strategy from that date of commencement that I had mentioned, you also need to know what your end goal is going to be. And I think too, like your first couple of cases, I don't think you really know what your end goal is. I think some folks with the fortitude are like, I don't care what my end goal is, I'm taking it all the way, whatever that means. And that's admirable for sure, but you got to know in the beginning in order to prepare correctly, because you might foreclose on something that you just never knew of. And I think filing, criminal complaints is one of those things where you just don't want to foreclose on anything that you could use to your advantage, at a later date. I think too, I'll just say, I don't know. I think people need to get a dose of reality of like, it's not that it's not that it's not right. It's that it's such a long process in proving so, and there's so much procedural stuff that you have to get through. So I think a lot of people get into this thing thinking it's going to be much easier than it actually is. It's not enough that it says it in the black letter law. It's not enough that you're innocent. It's not enough that they violated your due process rights. That all those things are not enough. Yeah, they're great, and yeah, you need them as elements, but that's not enough. And so yeah, I'm definitely going to be considering that. I mean, I guess the silver lining in all this, being kicked out of appeals court, is I get to start all back over again in state court. And so, yeah, the original motion to dismiss that I filed in there is going to be, amended and capture some other arguments that I feel like that were not argued the best that they could. But yeah, no, I like it. I like the approach. It was also interesting when I went back to that municipal court, and he got served the writ of prohibition. He tightened up real quick. He didn't even want to. He didn't want to talk. He didn't want to do anything. He just stuck his prosecutors on me, and they just, all they could do was try to motion that thing out of the court. So yeah, I wouldn't argue that at all. David's a beast too. That guy's a monster. I don't know how many people has read his stuff, his flash drive, but that thing is, ooh-wee. I wouldn't want to be on the other side of that table.
No, he knows his stuff, and he can recall it all from memory and just spit it out. Of course, I guess that's what 30 years of practice will do for you, right?
That's right. Yeah.
And so, did you start with some PRRs, or did you how did you gather the information from the cop and whatnot to write your motions? So did you start with public records requests? Did you or did you ask for the defense or from the court the reports?
Yeah, no, I haven't even got that far, honestly. So when I filed my writ of prohibition, like everything just stopped. And, that became its own deal. It stopped the municipal court from proceeding. All they could do is transfer it out. And then of course, when that got denied, everything stopped because of the appeal. So, we haven't even so my next appearance in state court, now that it's been denied, my appeal's been denied, is in July. So yeah, we're about to get to the thick of it, where discovery is going to kick in, and we're really going to start peeling the layers back and set up some post actions that we won't get into today, that I'm interested in doing. But no, haven't. Again, it was just and I'll tell you, I don't know, outside of the opinion from the judge stating that, hey, jurisdictional issues, you have to go through the adjudication process and appeal those at the end. I thought really by filing the writ of prohibition, that was kind of a fast track way of doing things. I would have appealed the motion to dismiss. But again, I didn't have anything in writing. And so I felt like, I didn't have that opportunity. And I was trying to stop this thing within like the 10 days or whatever they were trying to go to trial with. It was something aggressive. But I thought that, if the writ was denied, I could appeal that. And that would just be a faster way of having to go through the whole discovery process and blah, 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 blah. And turned out just being one big, huge waste of time. And, but it's okay. I think I didn't foreclose on anything. I didn't, waive any jurisdictional challenges, and I'm in a, good position, to appeal it after it's been adjudicated, which is, again, just a bit mind numbing. But no, the answer to your question, I haven't done any of that yet.
Okay, and so and you have another case about records, right? Going on?
Yeah, yeah, I do. And we hear this all the time. It's not the case is a bit more than a pissed off teenager stomping his feet because he didn't get an open records request fulfilled or what have you. And it was based on a new piece of legislation that had recently been codified. And essentially, it's in reference to the school district that we're in, and me trying to obtain some learning materials for my children. And the statute, what it did was it took materials and it classified them as instructional materials. And when you did that, the argument on the other side is that it forecloses your right to have an open records request on those particular materials. But that argument, it fails for many reasons. So, I mean, so the entire case is essentially, statutory interpretation. And so it gets into a lot of federalism because there's copyrights that are involved with certain things. And, is it a preemptive action? And, so it gets into a bit more technical things than just a simple open records request. But, I mean, as we all know, we all have a First Amendment right to comment, to criticize, and to scrutinize public expenditures. So anything that's a public expenditure, is not safeguarded by a legislative directive that offers an administrative remedy when you're not allowed to inspect and copy public records that are created with the public funds. So it's turned into a really, really neat, complicated arguments, in my opinion. Again, we have to overcome the copyright aspect of it. We have to overcome the First Amendment aspect of it. And then we get down to kind of the statutory construction of things. So, but yeah, those two are probably the most time consuming things.
And this game arose out of you just wanting to review the curriculum that your kids were being taught in school.
Very simple. Yeah, so simple. It's probably a $15 or $20 book. And I mean, frankly, they could have sent me the book. I think I was pretty ignited when they said, well, you could just go buy the book yourself. Oh, yeah, I could do that, right? If I hadn't already bought the book 30,000 times for the entire district with my taxpayer money, right? I could have done that. And furthermore, when did we enter into a society where you can give me your judicial interpretation of a statute? This is a newly codified statute, and you are interpreting it just like I'm interpreting it. And because you're, a public official or an attorney, your word is gospel. Like, no, sir. And this is something that is required a judicial decision on. And I mean, so it's a declaratory action, and it's the declaratory aspect of it is to declare the relation and rights associated with these two statutes that aren't in conflict of each other. It's funny because the statute and the new statute that's in question says that if you want to look at these materials, then there's a review period. This is what this opposing counsel is arguing: the review period, blah 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 blah. Well, the statute itself defines the review period, and it's the first 8 to 12 weeks prior to the adoption of that particular course. It has nothing to do with the same inspection and copying that open records request subjects all public records to, especially public records that are purchased with public expenditure. So, we're calling a red ball, a blue ball type of a deal. And, I'm sure that happens more times than not. But, so declaring that relationship between the two statutes and my rights, they're attached to it is one aspect of it. And then, of course, declaring if they violated the open records request by not giving me the total package of it all, and so what's interesting is that counsel has diluted his argument and tried to essentially provide affirmative defense as to why he was exempted from providing me those records, and that's supposed to hold precedent over the entire case, but it's not. Like, the declaratory aspect of the relationship between those two statutes, that's one thing. The next thing separate, right, is did they violate the Open Records Request Act? And this is where he gets into the copyright defense. Whereas, if something's copyrighted, well, first of all, there is no precedent in Georgia as it relates to materials that are copyrighted and, them being exempted from public disclosure because they are copyrighted. The only case that I found is out of Ohio that said, anything purchased with Ohio Supreme Court, anything purchased with a public fund is not exempted from Open Records Request Act. And furthermore, fair use kicks into play as well. Whereas, my intention is to, educate my child in the privacy of my own home. I have no commercial intent whatsoever. And, the exclusive rights that, if you look at Section 106 of the copyrights, the exclusive rights to copyrights are subject to Section 107 through 122, which are all the fair use, rights of private uses, so on and so forth. It's, as an example, teachers are allowed to copy books and use for their classroom for teaching. That is not an exclusive right that, publishers hold. And so anyway, his last argument, we're in summary judgment phase of that one. And his last argument was not even arguing the merits of all of this, but claiming preemption. Whereas, because copyright is involved, it's not a state court matter. It's a federal matter, and therefore should be kicked out into federal court. But again, this is the copyright assertion that he's making is just as an affirmative defense towards why they didn't fulfill my request. It still doesn't address what the entire action is about, which is a declaratory action about the relationship between two state statutes. That is an exclusive matter for the Superior Court. And just because a case involves copyrights doesn't mean it's preempted based on copyrights. It's not, as a matter of fact. And that's as it relates to federal preemption, it's a qualitatively different element that's involved in this case, which keeps it as a state matter. So, we'll see. There's certainly a relationship between opposing counsel and the judge on this case. The judge, when he was serving in the juvenile courts, he was actually on the foundational board of an entity that raised money for the school district. And when he became a Superior Court judge, he left that position. But lo and behold, the attorney of record of that foundation is opposing counsel now. So they've served together on the same board. They're buddies with each other. And, but I will say, look, for everyone out there, I like our judge. I'm going to say it. I like the guy. I think that, again, there is no precedence.
Yeah, we're seeing more and more of the secrecy that the state wants to operate in. In Chattanooga, they're trying to use some statute that they can't talk about, expunge records. In Louisiana, they're passing this public records request law that they don't have to answer all of them, and they're shrinking into secrecy, and that's not how a quote unquote democracy or a republic works. And there's only one reason that you want to operate in secret.
Right.
And I think Brandon brought a good point to this, that when everybody got sent home for COVID and the parents are looking over the kids' shoulders while they're doing their lessons. They were exposed to the curriculum, and that's probably something along the lines of how you found out. And let me ask you: is the book in question with the copyright? Is that something that was assigned to your child?
Well, so the material as a whole is the sexual education course in our school district, and there is one book that's a part of the the total material of the sex ed course that's copywritten. But yeah, I mean we recently moved outside of the perimeter to a more conservative, part of town. We lived in the city for about 10 years. And when COVID was going on, we were in the city. Um, and yeah, to your point, everybody went to digital learning, and I had to turn the toy room into a classroom and become an assistant teacher like real quick. And um, and it's look, I don't think that there's anything nefarious going on, and the in the sexual education course, like they would just be. I mean, I know in other states, I've seen it, and perhaps that goes on. In Georgia, we're pretty conservative over here. It's for me, you know, it's again this I can't say it enough. The doing business as usual. Hey, the statute says what I say it says because I say it says, and that's the issue here. It first of all, it's a new piece of legislation, and we don't have one case that the interpretation is delve into. And it's not because you say it is. As a matter of fact, your argument is wrong on its face because it defines its own terms in the statute itself. And so this is just a situation where I'm I'm tired of the being told that's the way that it is, and if that's the way that it is, then you're going to have to prove it to me, through our judicial branch. And oh, by the way, I mean every seat of office that there is, within that branch. So if we want to appeal this, all the way up to the Supreme Court, then we'll do that, But don't unless until somebody and look, I'm an honest guy. I'm a humble guy. If you want to show me something that says otherwise, I'll listen. And I'll take that into account. But this, the duration of the case and where we're at now is a product of you not being able to do that. You have not been able to defeat one argument. You get motions denied because of technicalities. You get this, that, and the other. Granted because of technicalities. But that again, merit for merit, it's not what it says. And you don't want to address that. You just want to talk about this red ball over here, and the blue ball all along is what we should be focused on. And it's that's the part for me. And it makes you feel like you're going crazy sometimes. It makes you feel like you've lost your ever loving mind. Like, no, man, like it says this, and why can't we just talk about that? Why can't we talk about the elephant in the room? Where it says you can't do that. Let's forget about all your, and I told the judge too, my last hearing, I'm like, we're going on 2 years now, and we're dealing with a question of law. We're not dealing with the question of fact here. This is the question of law. What does the statute say? And does that statute foreclose on my right to do X, Y, and Z? Period, point blank. That's what it is. The opposing counsel wants to, deter everybody and get them focused on the defense as to why they shouldn't be held liable for a misdemeanor. That's what the classification of the charge would be. Who cares about that? I mean, to some degree, I almost want to say I want to drop that aspect of the case and just get back to the law part of it, because it's caused so much delay, and who knows it. He probably would have found something, else to detract, your attention from. But anyhow, I was saying it in the group the other day. I'm like, when you go after somebody for damages, you turn this into a case about fact, and this is where it just goes forever and ever and ever. And not to say declaratory actions, don't have factual elements in there that need to be argued or proven, but a lot of times it's about law, and so, would that fast track the adjudication process? Probably not. I mean, probably not. In my simple mind, maybe, but it just so much of this this industry is about detracting from what's really going on, talking about something else, calling the red ball a blue ball. It's just infuriating for pro se's who do what the law is meant to do. You learn, you apply it. It says this, you do that, blah blah blah. And then the whole entire case has nothing to do with that. You're like, what is going on? But anyhow, that's my two cents.
It's just distractions and stonewalling. It's that what it is. Because if they read the law, then we'd be right.
If the law was on their side,
Right.
we would take our toy and go home. But it's just not. The people are here. We came to audit, and you don't have the receipts. What's going on? It's very simple. What have y'all been up to? How did you get away with this? What school did you go to determine that interpretation? I got to know. And so that's kind of how I see it. Just doing our part. But yeah, man, it's
the infiltration of the bar and the judiciary is apparent to all of us at this point.
Yep.
But as you said, if you want to get in some granular details about any of this, let's dive in.
Yeah. All right. Well, here, I'll share my screen. I figured the unregistered tag would be a good one to kind of dive in. I got my my appellate brief here, which kind of sums up.
I think you have to reshare your screen. Yeah, let me click on that.
And let me zoom in to make sure.
Well, so let's see if we're there. And we are, yes, and it's blown up sufficiently. Cool. Even I can read it on my small screen, so we're good.
There you go. Okay. Let's see here. I want to go to just kind of scan through stuff and go to the enumeration of errors, and we can talk through this stuff.
And which document is this?
So this is my appellate brief to the appeal for the denial of the writ of prohibition. This is all switching gears now to the violation, the alleged violation of the unregistered tag that I was pulled over and charged with. So, and if, for most people, that have been around the groups, we have our typical argument as it relates to statutory construction and the misapplication, thereof. This particular one is GA code 40-2-8. And we get into the enumeration of person definitions that we all come to love and argue about, so much. But that's one. Basically, the code was applied incorrectly. And then we have the Superior Court dismissed the appellate's writ without determining if the municipal court was vested with personal jurisdiction. This really gets into the processes of the interaction with the police officer on the side of the road and what he was doing. Do they have a right to arrest you for a statute that is not a breach of peace? Is he authorized to pull you, an individual, out of traffic for a Fourth Amendment violation to your papers? All of those arguments are kind of there. Subject matter jurisdiction is another error. It's not to say that municipal court doesn't have jurisdiction to adjudicate cases as it relates to traffic matters, but again, with the misapplication of 40-2-8, you can call it an adjudication of that privilege, but what other rights are at stake here, right? So if I have a constitutionally protected right to life, liberty, and property, and you're going to try to, via a legislative directive, adjudicate things based on a privilege as a citizen, then that's a problem. And we need a court with different jurisdictional confines than a dinky municipal court. So again, same, calling a red ball a blue ball to get you to strip you of your rights. Then we get to more procedural things. The municipal court exceeded its jurisdiction by not going through a commitment hearing, some pretrial hearings, not having a waiver in writing of jury trial rights. Those are those arguments. And then we have my assertion of there being a required trial for a writ of prohibition, regardless if a motion to dismiss has been submitted or not. So again, that's a bit more unique to the writ of prohibition. But anyhow, I just wanted to kind of highlight those things. I'm gonna, I'm not gonna go through every single one of them, but starting for the top, this is I'm sure you've heard this before. How everybody breaks down the statutory construction terms and how they apply and so on and so forth as it relates to misapplication of the code. But as we've read many times before, the state constitution, affords every one of the people a right to be furnished with an accusation or an indictment. And the Motor Vehicle Act in Georgia's Title 40, kind of circumvents that whole process, right? Because they've granted you a privilege, and then they say, oh, no, you can be prosecuted with a UTC, a uniform, traffic citation. And so let me get this straight. A legislative directive, from a public official that we elected to put in office is able to circumvent the document that empowers them by creating this UTC process to adjudicate one of my constitutionally protected rights. It's such an oxymoron type of an argument, but yet it's just doing business as usual. It's oh no, we've been doing that for 50 years. Who cares?
Right, and I don't remember the exact quotation of the Supreme Court case, but no state can take a right and turn it into a privilege and tax you on it.
That's right. They just,
but this is what they're doing.
And it's the age old argument, difference between locomotion and driving, and I don't want to beat a dead horse, but it's, again, I don't want to sound like a broken record either, but calling a red ball a blue ball, like do I have a right to locomotion or not? Is it driving or traveling? Blah blah blah. But at the end of the day, the legislators cannot create any process they want and call it due process. They simply just can't do that. This is an easy case here. There's many cases that say the exact same thing. That we cannot leave due process to the responsibility of the legislative power, in the state. So how are they doing this? And you dive a bit deeper into it. Now I'm probably gonna embarrass myself with the pronunciation of all of these, but these
you won't be alone.
Well, that's good. All the statutory canons that we've the Justum Generis, Nastiere Associus, and Expressio Unis es Exclusio Arterius. And three of them that apply, Justum Generis is, I stretch it a little bit. I'll be the first to say that I stretch it a little bit. But just to kind of dive through these things, again, when you have an action that gets commenced, it's being commenced on the side of the road. That is the first interaction of when you stop being a free American and are going through a process, whatever it may be. So in order to do that, you need to understand how the government official is authorized to act, or lack thereof. And if he's not, then you need to get into all of that. So there's a Supreme Court case here that kind of jumps into Justus Generis, and the concept is, it's of like kind. And so in this particular case, a gentleman was charged with, I think, stealing an aircraft, something along those lines, if memory serves me correct. But he was charged with a motor vehicle theft act, and they, gave the definition of all these motor vehicles, and it was actually overturned because it said, no, this guy stole an aircraft. It's something completely different than the enumeration of definitions here. and thereby you can't charge him with that. And so it's similar when you bring up the whole argument here is person. The definition of person in the GA code 40-2-8. And this is kind of the slick stuff that I don't know if I could point the finger at our legislators. I would more rather point fingers at the attorneys and the laziness of our judges, frankly. But basically the way for them to foreclose or erode your right to travel is to call it something else, and so they do. They call it driving, right? And any person. And so why would they go out of their way to define person? Why? I've never understood that, and until you start diving into it. And it's because certain subjects are bound by certain statutes. If I'm a semi truck driver and I'm traveling from state to state, selling product, delivering product, whatever it may be, I'm going to be bound to certain statutes that discuss those things, right? But me as a private individual, I can't be charged with a statute that's associated with a semi truck driver. So of course it makes sense to define your own terms, right? And just because the word person's in there doesn't mean that it means me. Once you get your head around persons and how it's lawfully applied, then it starts to make sense. But more or less, you take a look at the enumeration of persons, which person is defined in the same title. 40-1-1 43. Person means every natural person, firm, partnership, association, corporation, or trust. And once we get a bit further into this, you'll realize that it has to be of like kind, right? We can't, they have to be akin to one another, so to speak, as you'll see in this Supreme Court case.
Which with your airplane example, one flew and one drove on the ground. And there's a whole list of things that drove on the ground, and they tried to add airplane to it, and that just doesn't work.
Just doesn't work, no. And see, this my argument here is that peace officers, sheriffs, all these guys, they're simply not trained to judicially interpret these things. And I don't hold it against them that they don't know this, but this is what a probable cause determination hearing is meant to be, conducted by a judge, a magistrate, or a superior or state court. And in Georgia, it allows all different types of judges, but a unbiased individual who's been trained in the judicial arts of adjudication, not some $40,000 a year guy with a gun on the side of the street that says this applies to you because it applies to you. Like that's just not. That's why we have separations of power. So it's it's interesting how they try to make that fly. But similar to Justice Generis is the Nasir a Socius. And the easiest summed up way to say it is words should be judged in relation to each other because words like people are judged by the company that they keep. So you have to look at the entire context of the enumeration of words in order to obtain the accurate definition and how that statute will apply. Now keep in mind, the whole purpose of this investigation is to understand how it applies while maintaining the constitutional rights of an individual, right? So it has to harmonize with the Constitution, right? Both of them, your state and your federal. So, this is not just to see how it applies, but how can it apply while maintaining your constitutionally protected rights? That's what we need to get across here. So, anyway, I went, drill deep into Black's Law, several different, editions. You go back to the original adoption of the particular statute, and you can get some more, context as to how it's all applied, and everything that you would typically do with an investigation of that type. Blah blah blah. Same deal, and then you get the exclusios. I'm not going to pronounce this right. Let me go back up and make sure I give myself a fair shake at it. The expressio unis est exclusioso alterius, and it's basically if it's included, then everything else is excluded. And so when you come to the conclusion of your investigation, and you realize the context of the enumeration of words, then you realize that it could not include the people of the state with constitutionally protected rights. So if it did, and what's interesting about GA Code 40-2-8, another argument that I have is that it tells you what your fine and how it essentially assigns a cost and a determination of your guilt, so to speak, without consulting a jury. Which, if we know much about our state constitution, that's the exact definition of a bill of attainder. And so, any legislative act that's in violation of your constitution, i.e., any legislative act that's going to avoid consulting a jury, is not constitutional. It should be thrown out. Now, the only reason why they get away with it is because it's not applied to you and me. It's applied, when it's accurate, it's not applied to you and me. So, U.S. versus Brown. 381 U.S. 437 gets into the elements of a bill of attainder, which is an act of a legislative body naming or describe individual or group of people or entities imposing punishment first without consulting a jury for authority, which is exactly what this particular statute that I was allegedly in violation of is doing. So. This is a pretty good case. I liked it. It verbalized it pretty well. Let me see if that's better for you. Some subjects, it might be easy for legislators not only to declare a delinquency should be redressed by civil or criminal penalty, but also for it justly to assess and fix upon the exact amount of the penalty, or at least to set certain limits. As to other subject, the determination of the amount of the penalty or of the basis on which it justly should be laid may involve such an amount of investigation and a consideration of so many particular exigents as to make the fixing of the amount of the penalty only quasi-legislative, which is what this is, and predominantly administrative in character. And that's what it is. It's trying to administratively adjudicate a privilege. We are not getting into the merits of the constitutionally protected rights of the people. Had we done that, then the egregious violations of due process would be uncovered. So this kind of speaks a bit to context of the their violation to vest themselves with subject matter jurisdiction. Again, if this was a case to adjudicate the privileges of a driver, then you guys would have subject matter jurisdiction. But this is not. You're dealing with one of the people who have constitutionally protected rights to travel, and so it's not even in your cognizance. You don't even have the authority to even hear this matter. At best, what you could do is an investigative hearing to collect evidence or perhaps hear testimony and then bind the case over. But that's not what you're doing. You're trying to adjudicate the matters without a waiver of a jury trial, and you're trying to adjudicate it right then and there. Some defense attorney who dresses up and plays a judge for a day. It's interesting. So anyhow, that's the argument of misapplied.
There's a reason they don't teach this in law school or to judges or to the people, because it intersects with their revenue stream, and the municipalities, the ones that know it, are still teaching their officers the wrong thing, and that's why they can be so easily held accountable in a 1983 suit.
Yep, and it's if they were just to stick to making sure they handle the people's business and protect our constitutionally rights and avoid looking at how to make as much money as possible, it'd be a lot easier for these guys. I understand it would take a little bit more of manpower leg behind the judiciary, because so many people would be standing up for themselves. If they knew that they shouldn't be prosecuted for half the stuff that they're prosecuted for, it would explode the courts. But perhaps then they wouldn't be taking people to court or jail all the time at every whim. They would train their people better to, focus on real crimes, real things that we elected our officials to handle, not this make $1 billion revenue stream for themselves, based on definitions of terms and anyhow,
Well, how would they afford the parks, Brandon?
oh, that's right. That's right. Yeah. The wonderful parks. Yeah. That they protect so well. um,
Or the
so
water
the
supply, or the anything else they were in charge of, that they do terribly. But
Yeah, well, they just use the camera ticket ones to pay for all that stuff, not
oh,
this other stuff.
yeah,
That's how
gotcha,
they do
gotcha.
it. um, so the next one, enumerated error, is the personal jurisdiction. Again, this gets into the interaction with the police officer on the side of the street, and I thought it'd be important to read this from a case here, that false imprisonment and arrest perhaps is a little bit different than most people think it is. They think it's like handcuffs get thrown on you and you get brought to a prison cell. That is not what arrest is, and this case really puts it in layman terms, I thought, and so I included it. And it says false imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone, or by acts alone, or by both, and merely operating on the will of the individual, or personal violence, or by both. It is not necessary that the individual be confined within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be an injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intention, nor is it necessary that the act be under color of any legal or judicial proceeding. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause thereof, and by words or acts which he fears to disregard. So I don't know how many times I've been pulled over and I've had fear of disregarding what the police officer has commanded me to do. So by definition, that is imprisonment. And if there is not a ministerial duty or justification to a discretionary act of a peace officer, that is false imprisonment, and you can't be held liable to that. I think it's important to understand that. And again, when you're going through, setting out your strategy and your argument, um, you have to look at it from that context. Now, what also is important in my mind is that when you're dealing with a warrantless arrest, because that's what this is, it's an arrest. Then there's a whole different set of rules for a warrantless arrest, and this is where articulable suspicion comes in to play. You deal with and I'm not going to pronounce it right, the malleum per se and malleum prohibita, which basically means like acts of violence or breaches of peace or what have you. And so, if this is a misdemeanor, which it is, and it's not breaching the peace, then you don't have a lawful right to arrest somebody to do that. But yet, the police officer thinks that he does, and he thinks that their justification is that a crime was committed in front of me. Well, no. You determined that a crime was being committed because you violated my Fourth Amendment right, and searched my car and my license and everything to come to that conclusion. But prior to you doing that and violating my right, there was no crime. I wasn't in the middle of the street, shooting a gun. I wasn't, doing any of those things. I was driving and minding my, or I'm sorry, traveling and minding my, business, until you interrupted my day, and oh, by the way, your interruption constituted a violation of my Fourth Amendment right. And so in a normal, and now look, let's, play devil's advocate here. Nobody wants to get pulled over and taken in front of a magistrate court in the middle of a Tuesday afternoon for a probable cause hearing with a magistrate judge. If in a lot of cases, if you don't sign that ticket, that's exactly what you're surrendering to, or saying. You're saying that I want to be brought in front of a magistrate judge so probable cause can be determined. And so the thing that just blows my mind is that, first and foremost, if you don't sign that ticket, that doesn't mean that he can just arrest you. You can't use that as a basis to arrest a person. But however, they say that they can, and see, this is the weak link right here, because they say that by this action, by either you sign a ticket and you're giving bail, meaning you're waiving your right to a commitment hearing, or you don't sign the ticket and you're in violation and they can take you in front of a magistrate judge. however you cut it, there has to, you cannot waive a probable cause, determination hearing, and in Georgia now, the courts, the Supreme Court has clarified this issue and said that, and they phrase it as a critical hearing, that, if a probable cause hearing, it being determined, a hearing being had is a critical issue. It being an adversarial hearing is not a critical issue, because once you go through the adjudication process, you have a chance to, contest or object to any evidence that's in the record, and blah, 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 blah. Now, the adversarial aspect of it is a state-specific aspect. So not everybody knows that, where a probable cause determination can be done with the police officer and the judge, and you don't have to be there. That's not a federally mandated thing. But in Georgia, the adversarial aspect is a requirement. And so by you signing this ticket, what they're saying is that you waived your right, whether it be to a predetermination of that, or a post determination, via a commitment hearing. Our commitment hearings are for the determination of probable cause as well. Does the judge have enough evidence to commit you to these, proceedings? And we'll look at that as well. But the point being is that if it is a warrantless arrest, it's a misdemeanor, and you're not breaching the peace, he has no official authority to arrest you in the first place. So the authority he vested himself with was after he violated your Fourth Amendment right. Had that not occurred, he never would have had authorization to pull you over. He can't just pull you over. Had the alleged tag being expired, if that wasn't alleged, what would he have pulled me over for? Nothing. So anyway, that's the basis of the argument in terms of them failing to vest themselves with personal jurisdiction. You had to have gone through that process as well. Subject matter jurisdiction, as briefly mentioned, and here's a case that kind of speaks to it, is that the distinction between public rights and private rights is a prerequisite to the adjudicative authority that the municipal court possesses. Private rights to life, liberty, and property are those absolute rights that appertain and belong to men and women, and not to them as members of society or standing on various relation to each other. These are not dependent upon the will of the government. Public rights, by contrast, belong to the whole community, considered as a community in its social aggregate capacity. The distinction is significant because legislative and executive branches may only dispose of public rights at will, whereas judicial power is required when the government wants to act authoritatively upon core private rights that are vested in a particular individual. And so this is where, again, we get into the newly classified terms, of things, and throw it into an executive branch situation, or in a legislative situation where they can adjudicate things at will. But that's not what we're dealing with. And just because we call the red ball a blue ball doesn't mean it makes it so. So, in my particular opinion, my interpretation of all of this is quite literally what a writ of prohibition is for. This isn't like we just surrender to this make-believe jurisdiction that the court has created, whether it be personal or subject matter, and then go through the adjudication process, perhaps be found guilty, and then you want me to appeal and challenge all of these jurisdictional issues. These are threshold issues, folks. Like, this is, you can't just go pull a guy off the street and throw him into court for no reason. You were there, and you're only authorized to operate based on certain steps and procedures after you follow them, after you've checked those boxes. We haven't checked those boxes, guys. Like, what, so.
Yeah, a challenge of jurisdiction should stop everything in its tracks until proven. That's what should happen.
That's what should happen. The next part of this is the procedural, the exceeding their jurisdiction. Keep in mind, jurisdiction is a serious thing. It can be trapped. It can be challenged at any time in a process. And so if they exceed their jurisdiction by not adhering to a process, then they lose their jurisdiction. This is Uniform Municipal Court Rule 20.1 as it relates to pretrial hearings. And you can see here, in the case of a warrantless arrest, make a fair and reliable determination of probable cause for the arrest unless a warrant has been issued before first appearance. Inform the accused that he or she desires to waive these rights and plead guilty. Then the accused shall notify the judge in lawful custody, who shall in turn notify the judge. So 20.1 and 20.2, 22.2, these are all your pre-trial hearings that again get into making sure the court has vested itself with jurisdiction via a probable cause determination. Not to spend too much time on it, but of course there's many statutes that'll go into your commitment hearings as well, and make sure that all these are adhered to. And again, the just to be clear, the doing business as usual in terms of the taking your license and treating it as bail and that constituting a waiver of your commitment hearing is nowhere to be found in Georgia statute. That is a doing business as usual, just how we've always done it. It is not. As a matter of fact, there's 5 things that allow you to do that, and submitting your license as a form of bail ain't one of them. It's just not. So that's all I can conclude from all of that is it's doing business as usual. So that
policy,
I believe
policy.
Yeah, that's okay.
all policy. Just read the sign. It's policy.
Yeah, it's infuriating. The last one was again, it's an argument that I believe when interpreting the statute, it says that in terms of having a trial, a mandated trial, as opposed to hearing a motion to dismiss. My understanding of it is that we have what's called rule nisi. That's how we get hearings in the state of Georgia for anything outside of a summary judgment. So rule nisi essentially gets us hearings every 30 days, which is super nice. And on a side note, this is what infuriates me about attorneys that say, "Oh, just waiting for the judge to rule." No, you don't wait for the judge. You schedule your stuff. And in Georgia, we get hearings every 30 days. So every 30 days, I should be hearing what's going on with my case. So you can see, so as the statute reads, writ of prohibition, as our statutory construction is, basically the rules of procedure are the same for writ of mandamus. And so that's why you're going to see some of these statutes refer to a writ of mandamus, but it applies to writ of prohibition as well. So upon presentation of an application for mandamus, which is prohibition, if the prohibition nisi is granted, the judge shall cause the same to return for trial not less than 10 or more than 30 days of such date. Defendant shall serve at least 5 days before the hearing, blah, blah, blah. And again, it further drills this down and says, if an issue of fact is involved, it may be heard by the judge upon the consent of all parties. Otherwise, the case shall be set for trial upon the day of the next term of the Superior Court, as other jury cases are tried. And this was not done. She essentially used Rule 6.3, which says that a judge may issue an order without hearing oral arguments and everything except for summary judgments. And they're relying on that court rule and saying that forecloses the trial that's mandated here in this statute. So and the appeals court rested on her interpretation of that as well, which, again, it doesn't clearly say that this right is suspended if a motion to dismiss is entered. It doesn't say that at all. So, for folks that have been to state court or state appeals court in Georgia, the example I'll give is when you get your brief instructions, when you file an appeal, it tells you have 30 days to file your appellate brief and 30 days to file your motion to dismiss. The other side has 45 days or 15 days, after the appellate brief submits his, blah, blah, blah. But it doesn't say that the case stops. We rule on the motion to dismiss, and if he survives that, then we review the appellate brief. No. And in the appeals court, you submit everything, and the judge rules on everything right then and there. If he decides to dismiss it, yes, he dismisses it, but he still reviews the whole thing. As an example, in this particular appeal, I think that the opposing counsel didn't know that. And so they just filed a motion to dismiss, and they didn't file an appellee brief. And so when the judge went to his motion to dismiss was based on the fact that he transferred it out of state court, and therefore the municipal court didn't have a controversy in front of it at that particular time. So the whole thing was considered moot. Well, his self didn't submit the transfer order with his motion to dismiss, so the appellate court couldn't even rule on his motion to dismiss anyway. So he denied his motion to dismiss, and then immediately reviewed my appellate brief, and then denied it based on the fact that legal remedy was still available to me, i.e., go get convicted and then appeal, and then we'll hear your jurisdictional issues, which is just freaking clown stuff. But the point being is, like so many people talk. Again, I'm not totally familiar with federal rules, but everybody talks about 12b-6, where the whole process stops until the judge rules on this motion to dismiss. Well, in the appeals court in Georgia, that ain't how it is. Your briefs are due, your motion to dismiss is due, period, point blank, it's due. And the judge will rule on the totality of everything when he gets to it, which in my case was 7 months later. But so it's important, right? Because of course, which is, again, I don't know, I find it even more infuriating because I had an uncontested appellate brief, and the judge, essentially denied me based on the fact that I'm supposed to adjudicate the case. And I guess, I don't know, I guess is it an economical way of using judicial resources? Because I very well could be, found not guilty, and then it wouldn't even be an issue at all. Like, I can look at it from both sides, but my point is that a writ of prohibition is when that there's not additional legal remedy at your disposal. And the fact that I didn't get a written order to even appeal my motion to dismiss, the fact that I didn't get a trial for my writ of prohibition, and the fact that the police officer didn't have jurisdiction to start this legislative commencement action to begin with. My understanding is that is ripe for a writ of prohibition, but who am I?
I think we call it a kangaroo court.
Yeah, I think, and that's in Black's Law as well. I think that's defined there. But anyhow, so that's that. I got here's my opinion from the Court of Appeals, and I just highlighted these two spots that just a bit drives me crazy a little bit, but. Because operating a vehicle without a valid registration is a misdemeanor traffic offense, blah, blah, blah. There's no affirmative indication in the record that the municipal court was conducting a trial without obtaining a waiver of Spencer's right to a jury trial, which, yeah, there is, bro. There is no waiver. Where is the waiver? Show me the waiver that's in the record. And my brief clearly lays it out that there is not a waiver. So unless you can show me where the waiver is, that's clear indignation that indication that it's not there. Anyhow, the municipal court has jurisdiction over traffic matters, blah, blah, blah. So that's that. What is this? Allegations that the trial court lacked personal jurisdiction are issues that the petitioner may raise in an underlying traffic citation case, and again on appeal if convicted. Because dismissal of the writ of prohibition is authorized if the court has ascertained that the petitioner was not deprived of all legal remedies. And again, the legal remedy that they're saying is adjudicate the case, get convicted, and then appeal. That's my remedy. It's just hard to read. So anyhow, back down to state court, and We'll start all over again. We'll hit the motion to dismiss, and then if it doesn't survive, or if it survives, then we'll go to discovery, and we'll start deposing the police officer and going through that whole process, and then we'll get into the actual merits, I guess, outside of threshold issues. But I'd like to believe that with all of this done, I've pretty well preserved the record to challenge these issues on a future appeal. So that's what I got, man.
And so, if you do go and get convicted, is there a similar state statute that prevents you from bringing action against them, civil actions against them, if you got convicted?
Well, I mean, civil action in terms of like malicious prosecution or something like
Yeah,
that. I
something like that.
mean,
Yeah.
militia. I mean, false arrest or false imprisonment. No, I wouldn't be precluded from bringing those actions there. Um, but malicious prosecution, that has one of the elements is it has to be has to end it favorably for me. So if I get convicted, until I'll appeal it, of course, and then until the appeal is adjudicated, hopefully the appeal is overturned, and then that would earmark the ending favorably for me, and then yes, I could turn around and go malicious prosecution. Now, my understanding, and I'm focused on these strategies. I haven't gotten too deep into malicious prosecution, but my understanding is, I'm getting the municipal court judge, the state court judge, prosecutors. I mean, everybody's coming to that party. If I get overturned on the appeals court, so I'll look more into it when the time comes. But my whole action has to end favorably for myself. So we'll go that route. I got 2 years on false arrest, false imprisonment. So I'm watching that clock. I may end up doing it, um, but yeah, we'll see.
And so the statute of limitations of Georgia is what, 2 years?
For false arrest is 2 years if I'm not mistaken. Yeah.
Yeah. This 1 year in Louisiana for everything except for fraud
Is that right?
it's got to go. It's got to go.
That's tough. Yeah.
It's got to go. But anyway, it is what it is. So we're gonna wrap it up here. You got you want to say?
No,
anything?
yeah.
Say anything?
No,
Next?
that's good. Yeah. I just, no. I think that's good. It's a good stopping point, and just to reaffirm, I'm sure. Hopefully, now most people know it's like this is not traffic court. That is not a get rich quick type of a deal. I mean, again, I'm almost 2 years into this, over $100 ticket,
Right.
and so, but the point is the knowledge, and frankly, adhering to your responsibility as an American. I don't care if it's a piece of trash on the sidewalk you're getting violated for, or an unregistered vehicle allegedly. I don't care what it is. The lack of pushback is what we're seeing now. The government is a product of our lack of pushback, and so if you're upset with it, we can't just picket and protest. We have to utilize the tools our fathers gave us, and utilize them correctly. And as we discussed earlier, we have to be better and know the rules better than the other guy. We can't whine and cry when they win on technicalities. I mean, we can, but it needs to make us stronger. And they are going to win on technicalities. There is 50 years, 100 years of doing business as usual that we have to break through. And there's probably a handful of judges in America who are just waiting for cases like this to fall in his lap, because otherwise he's bound to just keeping his head down and doing the same thing over and over again. And so it's you just got to get to that person, and you might think it's small. What's the worth of arguing over a little $100 ticket? Isn't it easier? Yeah, absolutely, it's easier. And like, we all know the process of this, right? The emotional process of this, and I'm sure Tate's getting a bit of that right now. It's like you file something, you feel really good, then you get your opposition and you're down again. Now you're like, oh well, then you go and study, and you get your confidence level back up, and it's like this emotional roller coaster of, did I miss something? Is there a little T I didn't cross, or an I didn't dot? And it's such an emotional thing because it's so personal to us, right? And these attorneys, they're not personally attached to this stuff. They could care less. They could just care. All they care about those billable hours. That's all they care about. So, like, you got to be prepared not only for the duration of this, but for that emotional challenge. I mean, that is, I mean, your life is turned upside down answering this stuff and always combating something. At all times while you're in this process. I mean, I had another case that I got a settlement. I got an enforcement of a settlement, a motion to enforce, and I got an order for that settlement. And this guy turns around and files a motion to vacate that judgment. The guy defaults on the settlement, right? Like clear as day, doesn't adhere to the terms. I get an order to enforce that settlement, and then he turns around and files for a motion to vacate. It's like it just doesn't stop. It just does. Like even when you get a settlement, you still got to collect on that settlement. You still got a writ of execution you're going to have to do. You're still going to have to go through that process. Like it ain't never done until it's done, until that money's in your bank account or you get a not guilty or whatever it is, you ain't done. So, but it's our responsibility, and if it's not done, then, you can't complain about it later. That's all I'm saying.
You're absolutely right. And your conviction to the cause comes through loud and clear here, and it comes through in your writing when I've read some of your documents that you posted. So it is a commitment, and we've been derelict in our duty for so long that it falls heavy on the few that want to change it.
Yep, that's right. Well, I mean, as I said, thank you guys for creating a space where people can develop those skills and rely on each other. I mean, there's one or two places like y'all that aren't like y'all, but try to do the same thing. And without guys like you and Brandon, we just be a soft voice in a dark hole. So it's great. Thanks for what you do.
Well, I'm not sure that we've changed that yet, but we're definitely making strides, and it is a team effort all over across the board. And it's nice to be able to bounce stuff off of everyone in the groups that have done things that we haven't done yet, even because we've only gotten to one discovery. I'm in discovery in Chattanooga. The rest are delay. So it's good to see that other people are getting traction or going different places and learning new things, because we certainly need that for sure. But yeah. I want to thank you for your time today and sharing with us all of your documents. And I know that people will be blessed by hearing it. And I just want to appreciate and thank you for your time.
Yeah, absolutely, Gary. Well, you take care, my friend. Just holler at me if you need something.
Will do, my friend.